Professor Oona Hathaway will help us to understand these two elements. She could not be with us live, but she has pre-recorded a conversation that is really a good lecture for understanding such a complex structure for us. And let me tell you a little bit about Professor Hathaway. She is an internationally recognized professor of international law at Yale Law School and vice president of the American Society of International Law. That's why she had a conflict, because she's busy in the same conference like this. During her prolific academic career, she's well known for co-authoring with Scott Shapiro the book entitled The Internationalists: How the Radical Plan to Outlaw War Remade the World. A fantastic readings for all of us. She has a pre-recorded presentation, as I said, that lays the foundation for understanding two of the other essential elements of the United Nations, the Security Council and the International Court of Justice.
Hi, my name is Oona Hathaway, and I teach international law at Yale Law School, and I'm so glad to have a chance to be here with you today. So I have been asked to talk to you a little bit about two institutions, the International Court of Justice and the United Nations Security Council. And I'm going to try to give you a basic overview of these two institutions and kind of how they fit into global governance. I'm obviously not going to be able to do full justice to either of them, but hopefully you'll come away with a bit of an understanding of how these two institutions work. So a key challenge for international law is how do we resolve disputes between independent sovereign states? What happens if states disagree with one another? How do we resolve those disputes? Now, international law operates in a world of multiple sovereign states. There's no global sovereign that can compel the resolution of disputes. Now, from the perspective of domestic law, this is really pretty strange. The absence of a single sovereign seems like a deficiency. We don't have police. We don't have courts that we can compel people to appear before. But it's also a virtue, because this is what makes self-governance of states possible. Now, the way that this problem used to be solved was through war. This lovely gentleman here is Hugo Grotius. He's sometimes referred to as the father of international law. He wrote a book in the 1600s, The Law of War and Peace, where he lays out his theory of international law, which is grounded in the idea that states can resolve their disputes with one another by going to war. But of course, today, going to war is no longer legal. States are not allowed to go to war against one another in the UN world. The UN Charter prohibits states from using war against one another on their own. So how do they resolve disputes in a world where war isn't the answer? And the answer to that question is that there is no court with universal compulsory jurisdiction, but there are a wide variety of courts and arbitral bodies that can resolve disputes. And we'll talk a little bit about that broader set of courts, but focusing today on the International Court of Justice, which is one of the most important ways in which states can resolve their disputes with one another. Now, there's a wide array of international bodies that states can go to, and this is just a small picture of some of them. As you can see, the International Court of Justice is in the upper left-hand corner here. But there are lots of other bodies, some of them extinct. The Permanent Court of International Justice, which is the precursor to the International Court of Justice, no longer exists, for instance. But there are many other courts that states can go to resolve their disputes. There are also arbitral bodies. If you want the full set of these, this is from a website called the Project on International Courts and Tribunals, which lays out a bunch of different dispute resolution bodies that exist at the international level. But the key one, the central one we're focusing on today, is the International Court of Justice, which holds its hearings at the so-called Peace Palace. This is this lovely building in The Hague in the Netherlands where the court sits. This is the courtroom in which it sits. This is the dais. These are the judges that are arrayed, waiting for a case to be argued in one of the grand halls within the Peace Palace. So the International Court of Justice, as I mentioned, is the successor to the so-called Permanent International Court of Justice, which turned out not to be all that permanent after all. That court had been established under the League of Nations in 1922. The International Court of Justice was established under the United Nations when it came into being in 1945. All 193 members of the United Nations are ipso facto parties to the court's statute, which is an integral part of the UN Charter. Now, there are 4 different ways in which the court can get jurisdiction that are laid out here. Ad hoc, that is, that there's a special agreement between parties, between states. Treaty-based, there may be a treaty that sends disputes under the treaty to the International Court of Justice. A small number of cases arrive at the court under what's called compulsory jurisdiction. Both states to the dispute have to have accepted in advance the compulsory jurisdiction of the court in order for compulsory jurisdiction to exist. So it's rarely the case that both parties to a dispute have agreed in advance, but it does happen. And then the court also has advisory jurisdiction, where it can render decisions that are advisory. As it sounds, it's not binding, but it can help resolve disagreements about the proper understanding of the law. Now, only states can bring disputes to the International Court of Justice, but there are certain bodies that are not states that are allowed to seek advisory opinions of the International Court of Justice. So while the International Court of Justice is a really important institution, most disputes between states are not going to be resolved in front of the International Court of Justice. And decisions by the International Court of Justice are formally only binding on the states that appear before it, though it has become the practice for states to cite decisions of the International Court of Justice in other contexts as well. So how are the judgments of the International Court of Justice enforced? So imagine you do, in fact, succeed in getting a case to the International Court of Justice. A state brings a case against another state. There is jurisdiction. There is a decision. How does that get enforced? So generally speaking, that's not so much of a problem. Compliance with ICJ's decisions has generally been quite strong. Studies have been done of kind of the end results of these decisions generally find that states voluntarily comply with them. But if a state does not comply, there is a mechanism for forcing compliance. That is, it can be referred to the UN Security Council for enforcement. But this is an imperfect solution because, first of all, it doesn't happen that often. And second of all, even when a case is referred, the Security Council can choose not to enforce. And for reasons we'll talk about in a moment, the UN Security Council frequently is hamstrung by the fact that there are vetoes of 5 permanent members that can prevent it from taking action. So this brings us to the question, how is international law enforced? So we just talked about one of the key institutions for resolving disputes, but how does enforcement take place? There's no blanket entity with authority to use physical force to enforce the law in all covered jurisdictions. So there are no international police to enforce the law. And states themselves are prohibited from enforcing a law on themselves. They can't take the matters into their own hands because under the UN Charter, Article 2.4 prohibits states from using force against one another. So they can't use force to compel another state to comply with the law. So even for a good reason, they can't resort to war. So how can the law be enforced? Well, one answer is the UN Security Council, which is a key body of the United Nations and that sits on a regular basis to discuss disputes and resolve matters where international peace and security is at risk. Now, there are a lot of different matters the Security Council may take up, not simply matters where international peace and security is at risk. And it is one of its key functions is to provide a mechanism for states to get together and talk about important matters that are facing the world, not simply come to decisions about how to enforce the law, but one function that it can serve is law enforcement. So under Chapter 7 of the UN Charter, the Security Council has the power to determine the existence of a threat to the peace and to take action to maintain or restore international peace and security. So this is an exception to Article 2.4 if the Security Council, acting under Chapter 7, authorizes the use of force to maintain or to address a threat to international peace and security, then a state can take action under that resolution to the extent that it permits it. The Security Council is also able to resolve disputes between states under Chapter 6, and I know one of the other speakers will say more about that mechanism for the Security Council to help resolve disputes between states. So under Chapter 7 of the UN Charter, as I said, a resolution can allow states to use force to enforce the law, but any Chapter 7 resolution can be vetoed by one of the 5 permanent members of the Security Council, which are the United States, Russia, China, France, and the United Kingdom. And as you can imagine, these states frequently fail to agree. And that means the Security Council often doesn't act, even in cases where we think it really would be appropriate for the Security Council to do so. A recent example is the horrific war in Syria. There were several resolutions proposed to try and address the humanitarian crisis there, and they were vetoed by Russia, and therefore no action was taken to try and address that really terrible catastrophe. So the challenge that international law faces then is, how do you solve global legal challenges in a world of independent, equal, sovereign states? The International Court of Justice and the UN Security Council offer partial answers to that question. The International Court of Justice is one place where states can go to resolve disputes between one another, but honestly, it hears relatively few cases, and only states can bring cases against other states, and only in limited circumstances, so it doesn't solve all of the problems that we might face. The UN Security Council is also a key answer to that solution. It does have the power to authorize action to enforce the law and to resolve and address threats to international peace and security. But again, it's a limited answer because of the veto. It often doesn't act, even in cases where we think it might be appropriate for it to do so. Now, my colleagues who are on this panel will say more about the various institutions that exist through the UN. There are many other ways in which states can take action to enforce the law, including through what my co-author Scott Shapiro and I have written about called outcasting. So don't lose heart. International law really does have lots of different mechanisms for making it effective and for achieving the goals of the global legal order. But these are 2 key institutions. They're not perfect. They don't solve all the problems, but they play a really important role in maintaining our global legal order. So I hope you have a great rest of the conversation, and I look forward to hearing about it later, and enjoy the rest of the conference.